This was a train wreck for the Obama administration. This law looks like it's going to be struck down. I'm telling you, all of the predictions, including mine, that the justices would not have a problem with this law were wrong. This still looks like a train wreck for the Obama administration, and it may also be a plane wreck. This entire law is now in serious trouble. It's hard to imagine how things could be going much worse for the Obama administration.
I was holding my breath, in the Supreme Court courtroom as the Solicitor General defended the Affordable Care Act. In particular, what worries me, and I think should worry all of you, is the prospect of a 5-4 decision striking this down on what looks like partisan lines. And I don't have too much doubt that that's something that at least the Chief Justice of the United States is going to be taking very seriously. From my perspective, there were 3 particularly encouraging signs. There was an interesting point that Roberts made a couple of times on Monday, and that was he didn't think it made any sense to view the mandate as a freestanding obligation to purchase insurance, separate and apart from the tax penalty for not doing so. And if the Chief Justice says, look, I don't understand the idea that the mandate is a freestanding obligation. The mandate says purchase health insurance or else. Or else what? Or else you have to pay a penalty. And if he succeeds in persuading others on the court, and maybe all that's needed is that he himself may be persuaded, that the mandate and the tax penalty are part of an inseparable whole, and that the law simply says to people, you have a choice. It's not really a mandate, even though it's called one. You have a choice, either buy insurance or see your tax bill go up a little bit to compensate for the fact that you didn't buy it and are thereby imposing costs on others. If it's seen as a choice, and if you're not viewed as a lawbreaker, as long as you pay the penalty, though you don't comply with the so-called mandate, then the taxing power becomes a much more available basis to uphold what Congress did in the Affordable Care Act. And when the Solicitor General was pressed, what if somebody, for example, is on probation and is asked, have you violated any federal law lately? Could the person truthfully answer, no, I haven't, even though the person didn't purchase the required insurance, but merely paid the penalty? The Solicitor General said, I assure the court, and he's in a position to do so, given his pivotal place in the Justice Department and in the government, I assure the court that anyone who pays the penalty when required will not be deemed a lawbreaker from the perspective of the United States government. Well, given that assurance, it becomes considerably more plausible to see the law upheld under the taxing power, as Judge Kavanaugh suggested it would if the law were interpreted this way. Kavanaugh in the DC Circuit, in the case that I assigned. So that's one straw in the wind that I think is been more or less overlooked in the media discussions, but that I think could be very important. I do think that the court will surprise a lot of people when it probably upholds the Affordable Care Act in an opinion by another former student of mine, Chief Justice Roberts. I would expect the Chief Justice to write an opinion perhaps saying that the mandate isn't really a mandate at all, but a choice that people have, either to purchase health insurance or to pay more taxes so that there isn't as much free riding.
And I'm getting sick and tired of people marveling at each other for their so-called intelligence, when there isn't any. How many of you, when you considered every possibility here, you know what, I think the court's going to actually end up calling this a tax increase? Who in their right mind would think that? Who in their right mind would predict that as the ultimate way in which the case would be decided? Nobody. Every prediction under the sun, nobody predicted this. Nobody predicted this.
Always with you, it cannot be done.
I noticed while I was watching the argument some pretty clear signals from the Chief Justice, although I was surprised others didn't seem to note these, that he was considering the possibility that although this was called a mandate, since it operates exactly like a tax, it simply increases the tax liability of people otherwise eligible to pay taxes for those who would impose a free ride on others, that it's really a tax after all. And that's why I predicted before the decision that it would come out in favor of the Affordable Care Act and that the Chief Justice would probably, as I said on the air on a couple of stations, conclude that it was a tax.
All right, let me
that didn't surprise me. The argument was made by the Solicitor General, and I argued, as did some others, that there were separate stools on which Congress could stand. One of them on which we argued that Congress could stand alone is the taxing power. And indeed, in the fall of 1977, when Chief Justice Roberts was a student in my course, I was finishing up a treatise on constitutional law whose main chapter on the taxing power argued that that power was alone sufficient, given its breadth, to provide all of the incentives that Congress needed. The Chief Justice made a point in his opinion of saying that unlike the regulatory power, which perhaps needs some active involvement by people before it can kick in, the taxing power is specifically designed so that it can apply, for example, under a direct tax, it can apply simply for, as the Chief Justice said, for existing. It's very clear that the taxing power is broad enough to suffice here.
There's some analysis after this that the conservative scholars like yourself, Mr. Rifkin, lost the immediate battle but won a larger constitutional war in terms of limiting the federal government in the future on other issues. What do you think of that argument, Professor Tribe?
Well, I think the court, by a vote of 5-4, reaffirmed the existing limits on the commerce power. They didn't really impose any new limits. They simply said that there has never been a prior compulsion to purchase a commercial product, and that they were going to draw the line there. I don't think we're going to see lots of attempts by Congress to regulate that way, and because of the breadth of the taxing power, it won't be necessary. As the Chief Justice pointed out, instead of actually compelling someone on pain of imprisonment to, for example, install energy-efficient equipment in her home, what you do is increase the tax liability of such a person.
Everything is proceeding as I have foreseen.
I'm boiling mad and sick at the same time, and it's gotten here. Oh.